Hi, my name is Josh Stein. I'm an oil and gas lawyer from Houston, Texas. I'm here to talk about CLE for general practitioners. It's a beginner's guide to oil and gas leasing, and it's meant to cover the basics of oil and gas for people who don't practice in this area too often. I'm actually a Texas and a New Mexico lawyer. I'm going to be focusing on Texas law in this CLE. For the purposes of this CLE, they're basically the same between the two states. There's a couple of exceptions in New Mexico idiosyncrasies and Texas idiosyncrasies, but for the most part, most states follow what Texas does in oil and gas production, and the information here should carry over into those other states by and large. Anyway, to begin with, oil and gas, like all real property, follows the bundle of sticks theory. The first set of sticks in oil and gas is the mineral estate and the surface estate. The mineral estate and the surface estate are totally different estates and land. They are completely severable. It's very common for one person to own the surface and for a group of people to own the mineral estate, and it's the exception rather than the rule that the surface owner in Texas owns a large portion of the minerals. Typically, the minerals have been reserved over a period of time. The mineral estate has 5 components, so there's 5 sticks within the mineral stick. The first is the right to develop the property, which means to drill the property yourself. The second is the right to sign an oil and gas lease. This is also called the executive right. That's the right to let somebody else drill the property and to sign a lease allowing that. The third is the right to receive a bonus payment. A bonus payment is a one-time payment made to landowners in exchange for signing an oil and gas lease. It's an incentive to sign now and get paid now, as opposed to waiting what could be several years before oil and gas is actually produced from the property. The fourth right is the right to receive delay rentals. Delay rentals are historical. They're not really used anymore. A delay rental is a payment by the oil company to the landowner to continue the lease without drilling the well. Typically, those are now included in the bonus. So an oil and gas lease with no delay rentals, where the bonus has been has included the delay rentals, is called a paid-up oil and gas lease, which is far and away the industry standard. It's very rare to see delay rentals in a modern oil and gas lease. And the fifth and most important stick is the right to receive royalty payments. A payment on production is a royalty payment, and it's where people either make money or go broke in the oil and gas business. It's where the bulk of money goes, and it's what you need to be focused on when you're negotiating an oil and gas lease, is to make sure that your royalties are as high as they possibly can be. There's a couple other clauses that I'm going to talk about later on in this presentation, but for now, these are the 5 bundles to keep in mind. One of the common severances in oil and gas is a severance of the leasing rights from the royalty rights. So a landowner will reserve the right to receive royalty, but not the right to sign an oil and gas lease or to receive a bonus or to develop. And that is called a non-participating royalty interest. It's non-participating because they don't sign leases, and it's a non-possessory right to receive money without any right to lease the property. It's an important distinction to keep in mind, because typically the two types of interests in mineral property are the mineral estate, which is the right to sign an oil and gas lease, and the non-participating royalty interest, which is the right to receive payments. Typically, a mineral owner will also own some royalty rights, although it is not unheard of for the mineral owner to have no royalty rights and only leasing rights. A lot of them don't know that they own only leasing rights, but sometimes they learn the hard way. Anyway, oil and gas leases are not leases in the typical sense of the word. They're not leases in the sense that you can lease a car or lease an office or an apartment.